In this presentation from the Delhi Law Academy on the Indian Penal Code, we shall study the crime and punishment of culpable homicide. Homicide is a Latin term in which homi means human and sido means to cut. Homicide literally means to kill a human being through another being. Culpable homicide is a blameworthy homicide. In India, culpable homicide is an offense and is punishable. It is punishable in three different ways in sections 302 and 304. But punishments later. First, the definition. The offense of culpable homicide is defined in the Indian Penal Code in section 299. And here is how it is defined. Whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act to cause death commits the offense of culpable homicide. Whoever causes death. Whose death? Section 46 IPC says that wherever the word death is used in the IPC, it refers only to the death of a human being and not to the death of an animal. So, in section 299, when we use the word death, it refers to the death of a human being only. What is the offense of culpable homicide? We find from section 299 that there are two major ingredients of this offense. The actus reus, which means the guilty act, and the guilty act here is causing death of a human being by doing an act. The second component is the mens rea, the guilty mind. Section 299 says that the guilty act must be done with the intention or knowledge which is specified in the section. Next, the word death has been used at several places in section 299. Does it refer to the death of the same human being everywhere? That is, whether the person whose death is caused should be the same person whose death was intended, or in other words, could the person whose death is actually caused can be different from the person whose death was intended? This is the answer. It is not necessary that any intention should exist with regard to the particular person whose death is caused, which means the person whose death is actually caused may be different from the person whose death was intended. When a shot aimed at one person kills another person, it falls squarely within the definition of section 299. Similarly, where a poison intended for one person is taken by another person, that also will be squarely covered by section 299. Next, the word likely, as it appears in the mens rea part of section 299 at two different places, conveys the sense of probable as distinguished from a mere possibility. I shall now explain two of the more important illustrations appended to section 299. Here is the first illustration. A lays sticks and turf over a pit. This is the act which he does, laying sticks and turf over a pit. And what is the mens rea? He has the intention of thereby causing death, or he has the knowledge that death is likely to be thereby caused. So he does this act with this intention or knowledge. Z, believing the ground to be firm, treads on it, falls in and is killed. Here we can see that the intention of A is not directed towards Z necessarily. In fact, when he lays the sticks and turf over a pit, he has no particular person in mind. Z happens to be the person who comes that way, he treads on it, falls in that pit and is killed. A has committed the offence of culpable homicide within the meaning of section 299. This illustration shows that it is not necessary that the intention to cause death should be towards any particular person. In fact, it could be quite general in nature. In this illustration, the intention is to cause death of whoever comes that way and walks on the trap. Here is the second illustration. A knows Z to be behind a bush. B does not know it. B does not have the knowledge that Z is behind the bush. A intends to cause death of Z, or at least he has the knowledge that by his act Z's death is likely to be caused. With this intention or knowledge, he induces B to fire at the bush. He instigates B to fire. Accordingly, B fires and kills Z. The act which causes death is done by B, but he has no guilty knowledge or guilty intention. He has no mens rea. Therefore, in this case, B may not be guilty of any offense. He does the act, but he does not have the mens rea. What about A? He does not do the act which kills Z, but he instigates B to do that act. Section 299 says, this illustration says that A has committed the offense of culpable homicide because he has the guilty intention, he has the guilty knowledge. From this illustration, we say that an abettor can be held to be guilty of committing the offense proper. In the absence of this illustration, A would be guilty of abatement only because he had instigated B, he had induced B, but by force of this illustration, he is to be held guilty of committing culpable homicide itself. This is the import of this second illustration. We shall now take up two provisions of section 299 which further explain the meaning and scope of the offense of culpable homicide. First, a person who causes bodily injury to another who is laboring under a disorder, disease or bodily infirmity and thereby accelerates death of that other shall be deemed to have caused his death. Here, the person whose death is actually caused was already suffering from, let us say, a serious disease, even a terminal disease. If a person accelerates death of such a person, he shall also be deemed to have caused the offense of culpable homicide. Next, causing death of a child in a mother's womb is not homicide, but it may amount to culpable homicide to cause death of a living child if any part of that child has been brought forth, though the child may not have breathed or been completely born.